Our world is lost in unnecessary fear and hurt. Our systems seem scientifically engineered to make you small, powerless, and always waiting for the next great leader who will fix the problems around us. Worse, we're witnessing neighbor versus neighbor while warfare breaks out around our family tables. But you have access to a spirit, a strength that enlarges and empowers you. Even better, you don't need to wait for the next big movement. You can heal the world. It's time for governance by grace. Welcome to Gracearchy with Jim Babka. Supreme Court decisions tend to make people hysterical. And right about now, that's very true. Today, we're going to talk about one case in particular, which was huge in its implications, a major landmark. And that case is called Loper Bright Enterprises. It was the biggest case since Dobbs because the justices repealed Chevron deference. Chevron deference? Jim and I like how Spike Cohen describes this case, and I'm going to read to you his tweet on X. It's long, but I promise you it's worth your time. If you take nothing else away from this episode, listen to Spike's words. Here we go. For those who do not understand what Chevron deference is and why the Supreme Court ended it, here's the long and the short of it. And I'm quoting Spike. A family fishing company, Loper Bright Enterprises, was being driven out of business because they couldn't afford the $700 per day they were being charged by the National Marine Fisheries Service, an agency of the federal government, to monitor their company. The thing is, the federal law doesn't authorize the National Marine Fisheries Service to charge businesses for this. They just decided to start doing it in 2013. Why did they think they could get away with just charging people without any legal authorization? Because in 1984, the Chevron decision, the Supreme Court decided that regulatory agencies were the experts in their field, and the courts should just defer to their interpretation of the law. So for the past 40 years, federal agencies have been able to interpret laws to mean whatever they want, and the courts just had to go along with it. It was called Chevron deference, and it put bureaucrats in charge of the country. It's how OSHA was able to decide that everyone who worked for a large company had to get the jab, remember that? Or be fired. No law gave them that authority, they just made it up. It's how the ATF was able to decide that a piece of plastic was a machine gun. It's how the NCRS was able to decide that a small puddle was a protected wetland. It's how out-of-control agencies have been able to create rules out of thin air and force you to comply. And the courts had to simply defer to them because they were the experts. Just imagine if your local police could simply arrest you for any reason, and no judge or jury was allowed to determine if you'd actually committed a crime or not. Just off to jail you go. That's what Chevron deference was. It was not only blatantly unconstitutional, it caused immeasurable harm to everyone. And thankfully, now it's gone. Loper Bright and related cases will be used for years to come to roll back federal agencies, and we'll all be better off for it. And that's why politicians and corporate media are freaking out about it right now. Thank you, Spike Cohen. Well, it just so happens that Jim Babka has been involved and nationally quoted on the general issue of bureaucrats writing the laws, because he co-authored the Write the Laws Act. Plus, Jim's downsized DC organizations filed an amicus brief in this specific Loper Bright Enterprises case where they called for an end to Chevron deference. Jim, first, congratulations, man. And I know you think that they didn't go far enough rolling back the Chevron deference, right?
Yeah, indeed. They should have gone back all the way to 1787. They only went back to 1946 and the Administrative Procedure Act. But and what's been missing here and what has been on my heart and mind over these many years has been the separation of powers, which were addressed in Justice Thomas's concurring opinion. There is the separation of powers is a form of check and balance where you've got the various branches And there
Yeah,
are
there's
only
three
three
branches.
listed in the Constitution. Let's list them out right now. First, there is the legislative branch. Then there is the executive branch, and finally there is the judicial branch. So that's it. That's the whole government right there. There's been times when people have said there's a fourth estate. They're referring to the media's ability to also provide a check. The pretense of Chevron was that there is a fifth branch of government, basically, and that's the unelected bureaucrat. And we're going to see as we go through this that they allowed themselves to be judge, jury, and executioner. They were prosecutor, court, and administrator all together. They did everything.
Bureaucrats, the bureaucratic level.
Yes.
Now, quick question: is this the same as the deep state? Is that what we're talking about here?
Well, there's a heavy overlap between those concepts. In a Venn diagram, there would definitely be overlap. There are elements of the one of the things that you have to understand about the bureaucracy is that these people stay. The politicians change. We talk about term limits here all the time. There is no term limit for people who serve in the bureaucracy.
Right. They are unelected, by the way, too, right?
Right. So the idea is that Article 1 was the most important. It was, these are co-equal branches, but the most important, if you're trying to say which one has the highest priority, it's supposed to be the People's Congress. That's supposed to really be, that's where the spending bills originate. Everything is really, at the end of the day, a funding question. If zero funding has been provided for something, that means it can't be done. That is where it begins. But the legislative branch has gotten lazy. They're much more concerned with fundraising and giving speeches and appearing on television than they are actually sitting down and actually dealing with the intricacies of the laws that they pass.
That's called what? Oversight?
Oversight. It is that, but think about the laws that they're making too. So
I'd rather not.
So in the separation of powers arena here, Nancy Pelosi got up. It's not many years, and people have started to forget about the fact that this happened. But she said about Obamacare, about the ACA, we're going to have to pass it to find out what's in it. And I have been interviewed because I also co-authored the Read the Bills Act. And a lot of people go, oh, yeah, she's talking about Read the Bills. Actually, she wasn't. There were over 130 different boards, committees, and agencies that were going to be created as a result of the ACA. And because of that, she couldn't possibly know how the law was going to be carried out because the people hadn't been hired yet. They hadn't gotten their office yet. They hadn't started to write anything down yet. They hadn't had any meetings yet. So she couldn't know what was actually going to happen in a lot of cases. This level of deference to unelected officials, I'm going to give a remedy to it today, is completely out of hand. And that remedy is related to the Write the Laws Act, which we will explain in detail later. Yep. Chevron deference, I don't want to gild it. Spike already described it, but it basically meant the key word is ambiguity. If there was any ambiguity, they were supposed to assume that the experts knew what the heck they were talking about.
Right.
Period. Yeah. Full stop. It's over. There's nothing further. We're not going to look at the merits of your case because they're the experts, and that's the end of it. So we did file an amicus brief in the Loper Bright Enterprises case. We had our fingers crossed the whole time that it would happen, but additional good stuff has happened just in the last several days with the rendering of this decision, also involving the Administrative Procedure Act and the administrative state. So I want to get into some of those things today. And the way I would like to do this is I would like to go, I have no idea. I didn't know who this was before today. This is apparently an MSNBC host. His name's Ali Veshley, and apparently he fills in on Fridays for one of the other shows. I literally don't know anything about this guy. All I can tell you is I watched this interview 5 times and he's completely out of his depth. Yeah. He does not know what he's talking about, and he's hysterical at points. It's really kind of over the top. So I want to go through the clip if we could, or through clip by clip, but we've grabbed nearly a dozen clips that I want to use as kind of the show outline, and I want to give comment on the things that they're saying. So why don't we start off right away with clip A, if we could, please.
Here we go.
Supreme Court's conservative supermajority dealt a serious blow to democracy by overturning the 40-year-old legal precedent known as the Chevron doctrine.
Yeah, so I want you to notice, and this is going to happen repeatedly throughout this, that the language here is incredibly loaded. The conservative supermajority. So the court isn't, we can have a debate about whether or not it's conservative, but supermajority, the difference between a majority and supermajority in this case is literally the number 1. That means you, instead of having 5 justices that tend to lean conservative, you could argue that there are 6. what we will do differently throughout this discussion is we will steelman. In fact, we will deal, the reason we're playing their clip is we will take what they believe are their best arguments and respond to them. I will, in one case, even help them improve their argument.
Yes.
Let's go ahead.
In what many court watchers are calling a judicial power grab.
So this is the most loaded language of all. And the phrase judicial power grab, Bill, started appearing in headlines all over the place. It was a coordinated effort. It was probably decided days or weeks in advance of the decision coming down. As you can attest, Bill was texting me every day. Loper Bright hasn't come down today. No Loper Bright news today. Like, we were doing this every day because we were waiting for this decision to come down. And it actually arrived at the most inconvenient time because I was on the road, because otherwise we'd have been sitting down here even sooner having this discussion. But you're going to keep hearing this idea of a power grab. There is no power grab here.
It's not a power grab, people.
No. The bureaucracy could still do pretty much everything it did before. The difference is individual human beings, citizens or even companies who find themselves in a situation now have new power to go to a court. And I say new power because that was stolen from them for a mere 40 years. For a mere 40 years. 1984 is not that long ago. For a mere 40 years, that power has been stolen from them. It was there. It's in Article 3, and it's in a case we'll get to in just a moment.
This longstanding principle required courts to defer to federal agencies' own interpretation of laws that they administer in the case of ambiguities or questions about enforcement of laws.
So ambiguity is the key word here. If something was uncertain or unclear because it was of a technical nature, that's it. The case gets kicked out. Chevron was a two-step test, and the second test dealt with this ambiguity thing. It was almost as if, well, they're using words, they're fairly technical here. Guess we can't comment. And that's always been illegitimate for reasons that we'll go ahead and describe here. But what it meant was that a group of people, as we pointed out at the top of the show, who were never elected and who probably last more than 6 elections, right, get to make these final decisions.
Now, this is just sensible. It's how functioning governments work. Congress or a legislature cannot possibly anticipate every question that might arise about any given law that's passed.
Okay, so here's where I want to help them out. And I'm going to do them a service a solid, as progressives, that they were not willing to do themselves. Like, I listened to this whole thing, and I was amazed at how weak and ineffectual several of the arguments were that they were making. Like, if I was going to cartoon them or straw man them, I would have made some of the arguments that get made in here. You'll get to see one really dramatic example here in the mix. They just really clowned themselves in a lot of ways. And there actually are arguments to be made for why this deference exists. So I want to talk about this from a values perspective. And I want to suggest that what a progressive is. And I'm going to say first, without apology, that I'm a libertarian. And so as a libertarian, I'm not like fetishistic about democracy. I think it's one of many ways to make a decision. And in terms of the qualities or numbers of ways to make a decision, it's fairly low in terms of its quality level. And so, like, I'm not interested. Like, there's lots of people say, we got to do what we can to preserve the democracy. You're not going to get me at that party, right? We're going to go marching. I'm going to stay home and watch television. Democracy is not high in my rank of values. I don't think it's an effective way to figure out morality and ethics, for example.
It's terrible.
How many people can we put on trains and ship them off to camps, right? What's the percentage of vote that we have to do that?
51. Or
Right.
50 plus 1.
So I'm suggesting that it's not really a great tool in a lot of situations. And we've talked about that quite a bit over the course of the show. But progressives don't believe in democracy either. And they pretend, in fact, they overtly exaggerate their affection and love for democracy. And if they do actually, or if there's any way in which they're telling the truth, what they mean, let me break down the word in a completely different way. Archy, we have Gracearchy. Archy is governance. Okay, so that's what we're talking about here. How are we going to govern?
How are we going to govern?
The demos is the citizenry. It means that citizens govern. Now, what that means under normal circumstances is we are actually the boss. So we went through Article 1, Article 2, Article 3 before. We talked about the three branches of government. There's one that chooses who those people are ultimately. There's one that kind of starts the ball rolling. There's one that had a social contract that gave their powers. That's the theory, okay? And that is the citizenry. And that is normally what the democracy means. It means people vote. And you probably are under the misapprehension that that's what a progressive means when they say it, but they don't mean that. What they mean is that the government cares for the citizens. And I'm going to break down exactly how that plays out as we go. But it's an unfortunate way to look at the world. Now, I'm moved. I pulled up a whole bunch of Bastiat quotes, but in the interest of time, I'm going to focus on my absolute favorite one. If the natural tendencies of mankind are so bad that it is not safe to permit people to be free, how is it that the tendencies of these organizers are always good? Do not the legislators and their appointed agents also belong to the human race? Or do they believe that they themselves are made of a finer clay than the rest of mankind? The organizers maintain that society, when left undirected by them, rushes headlong to its inevitable destruction because the instincts of the people are so perverse. The legislators claim to stop this suicidal course and give it a saner direction. Apparently, then, the legislators and the organizers have received from heaven an intelligence and virtue that place them beyond and above mankind. If so, let them show their titles to this superiority. I will tell you that in conversations that I have in another role that I play with the Foundation for Harmony and Prosperity, where we do these one-on-one dialogues with people, this is a common thread. There is a belief that people are too stupid or too base or too immoral or not able. There's externalities. There's all these excuses for why they don't know what's in their own best interests, and we, their betters, know better.
Oh, sure. You've heard it. Womb to the tomb, right?
Right. And we summed this up in one of our mental levers, which I will put down in the show notes. You're too stupid. Like Gary Nolan, when I go on his show, this is a repeated theme that comes up again and again. Why do we have to have this regulation or that regulation? Why do we have to protect you from tobacco or whatever, or tobacco alternatives? Why do we have to do these things? Because you're too stupid. And we're going to see one other thing happen here in the course of watching these clips, and that is that they don't think that the people are the only ones that are too stupid. They pretty much think there's a unique class of only them that is not. So they don't believe in democracy in the way that you and normal people would typically define the word, the way you were taught it in your civics class. They either have a different definition of democracy, which if they were honest about it, they would just simply say, right?
Right.
We care more. Like what we notice is nobody else cares. We care. That argument isn't raised once. Scare tactics will be used several times. Exaggerations and even lies will be used in the course of their argument here. But they never once say, you know what? We really care. And we're going to be honest with you. We're going to look you right in the camera and tell you, we think you're too stupid and we should be caring for you. In fact, everything should be handled by an expert. Everything should be centrally planned by an expert.
Unimpeachable expert, by the way.
Exactly. Unimpeachable.
Unelected, unimpeachable expert.
But they're not willing to be honest, and that really is their best argument, because a lot of people believe that most people around them are stupid. And that argument will have some trunk, but they can't say that part out loud, apparently. They have to let you believe that democracy is what they're really for. So much so that Barbara Streisand goes out and tweets about this, and she's bemoaning the loss of democracy when exactly the opposite, as we're going to illustrate, happened here.
So it typically, and again, it's not just in America, it's all over the world in working democracies. The legislature typically delegates that sort of authority and enforcement to experts at the federal agencies who actually administer the law. For example, the scientists at the Environmental Protection Agency, or the public health officials at the CDC, specialists in their respective fields who can interpret complex regulatory matters. Now, Friday's landmark ruling shifts that final say on ambiguity in federal laws from these experts to unelected judges at the federal level. potentially including those on the conservative supermajority of the U.S. Supreme Court.
So there's heavy use and emphasis. He even says it in a certain way on the word expert.
Yep.
So you just heard what I was already setting up in the previous clip. Expert is the key. This is ruled by experts, and what it is not democracy, it's technocracy. It is the idea that there are people who know better than you, and they should be able to write the rules of the road. They should have a great deal of influence and control over your work and over your daily life and over the items that are in your home. They should be able to make those rules because they are clearly of finer clay in some way, but they're not making, fairness to them and versus Bastiat, they're basically saying that the expert knows this field so well that you couldn't possibly know that field so well. And there's so many fields to know that they have to take care of you, as you put it, Bill, from cradle to grave. The other thing that he does here, the other loaded word he uses is unelected judges. Now, this is a blade that cuts two ways. And the sharper side of that blade is that the bureaucrats themselves are unelected. And we have a civil service, so they are career, right? So they come in and they stick around. Federal judges, on the other hand, these are positions that have to go through a confirmation by the people's body. The Senate has to confirm them. And secondly, they are an Article 3 spelled out existing constitutional function, whereas the bureaucrats are not. And they have been created by a whim. I'm going to show you how simple this is and how bad it is. We've already talked about the ACA, right? And how there were more than 130 of these agencies. In fact, let's just say it now. Let's just say that they pass a law and they don't know what's in their law. And this is the routine thing that they do. And they leave all of the hard work. I want to be clear about this. There's a certain degree of grandstanding that comes with the ability to be a congressman. I took on X or I fought Y, and they get up and they say that to cheers. But what they did is they passed a sparse law where the only things they cared about were the cutouts for the pork that needed to get back home and maybe the toggles or switches that they needed to do to take care of a particular constituent. So they might do some special favors for some constituents on the way that the bill passes, but they leave the overwhelming majority of the hard work to the bureaucracies to read what's been given to them and then subsequently figure out how to go about implementing it.
Right. With, by the way, very little fiscal responsibility for how that gets done.
Correct.
Because nobody can challenge it.
Nobody could challenge it. And traditionally, the Congress, who would prefer that these things were being handled by them, would like to be in the following enviable position. They have all the control and none of the responsibility. The dream for everyone is to have full control and no responsibility. It's not a very effective formula for getting things done, by the way. Somebody's got to take on the responsibility. And if they don't have any control, they're not as good at doing what they're supposed to do. Congress routinely says to the bureaucracy, go ahead and do this. By the way, at any moment, we could show up and call you before us and smack you around on C-SPAN cameras. Maybe some media will even show up and look at how stupid you are. And we're gonna even demonize you. We'll run whole, direct mail campaigns and fundraising campaigns about how evil and bad you are. We'll grandstand this stuff because we weren't willing to do our job. We weren't willing to vote on what regulation was absolutely necessary. And that's where the Right to Laws Act is going to come back in.
This effort by conservatives is detrimental to democracy because regulatory oversight by specialized agencies serves as a critical defense against predatory practices by companies and industries. It helps stave off the corrupting influence that money and privilege have in American politics. While you may have limited interaction with Congress and with your elected officials, the decisions made by these government agencies shape many aspects of your life, your health, and your money.
And I have to immediately ask, as I hear him say that, shape your life, your health, and your money. How's that going for you?
Yeah, exactly.
How's it going for us?
Right.
So the Department of Agriculture, because they were not in the least bit influenced by any outside corporate parties.
Of course not.
Came up with the food pyramid. And the food pyramid is a recipe, literally, for trying to give yourself heart disease. Diabetes. Diabetes is even a bigger deal, right? If you follow the food pyramid, say hello to diabetes. The things that they told us about fat turned out to be wrong. And it turns out there's a lot of things that they said as they went into a war on fat. Okay. How about the FDA? The Food and Drug Administration's procedures create an arbitrary lag that makes it take years for something to get to you because the efficacy also has to be tested.
Sure.
Right?
Yeah, it
Now,
takes.
listen.
Well, when I was involved with a process like that in the late 80s, the timeline was like 15 years to get all the trials done to bring a new drug to market.
Yeah, it's typically 7 to 10. There may be some cases that take longer. And part of the reason, I was aware of a particular form of muscular dystrophy, Duchenne muscular dystrophy, several years ago. And we came across a story, and this is going back about a decade now, of a drug that was literally, there were 2 boys in the same family, one of whom was allowed into the trial, and then the other was diagnosed but could not get into the trial. So the family's using the drug, and the other child is wasting away because they don't have access to the
control
drug.
Group right there.
And okay, I am so glad we have experts that are making these decisions, and this is how they've laid out that this should be done. And I'm glad that they didn't use any arbitrary power to help out this family. I mean, that's just, that would be something else.
How undemocratic of them.
Oh my gosh. So we could go on all day. FEC, these are Incumbent Protection Acts. And surprise, surprise, they tend to be made on partisan basis. In fact, the way the law is written, we talked about this in a previous episode, the Commission on Presidential Debates being divided between Republicans and Democrats. Well, guess what, brothers, sisters? FEC is also divided half between Republicans and Democrats. The board that runs that thing is half Democrat, half Republican, and they make decisions that benefit their party, and they've split. There's typically 3 to 3 splits because each party is trying to use this government agency for their advantage. So I am so glad that for 40 years, the court was deferring to this procedure, right? Just trusting that they knew what they were doing.
You have every confidence, Jim. I applaud you.
All right, let's go to the next one.
Friday's ruling effectively undermines both the legislative and the executive branches of government by prioritizing judicial judgments over agency expertise. And in doing so, it diminishes Congress's ability to legislate effectively by delegating to these special agencies. The winners of this ruling, make no mistake about it, are likely to be large corporations.
You've heard of the boogeyman, right?
Oh my gosh, yeah, here he comes.
Yeah, you've heard of the boogeyman. So the big corporations are the ones that are going to get away with this.
Oh yeah.
All right, I want to continue the theme we were talking about in the previous clip, because first, it is the case that large corporations already participate in a process called regulatory capture. So we talked about the FDA. There are a small handful of very large companies where they actually, it's from their own staff, it's from their own team, that the people that get appointed to be on the commission, to be the board of directors for these various agencies, come from the industry that they're regulating. This is normal.
Yeah,
okay?
I've never heard of that anywhere, like
they also
Defense or any other place.
Correct. And the same thing's true. Sometimes they slip in an academic, but that academic was typically the beneficiary of grants from the industry. This is very common that this is the case. And the people that work inside the agency, if they are to leave, it's because they got up to some level of responsibility. They were really good in dealing with a particular company. The company appreciated their help, and they hired them to come on and take a role. And you just mentioned the biggest one, which is the Pentagon. Generals routinely walk across and join some industry that they were previously buying from.
Sure. Like, what is that book, The Shadow Factory? I mean, you can read about this. It's not a secret, anybody.
It's not a secret. In fact, if you don't see the Pentagon as anything other than the world's largest purchasing department, you're completely missing the point. And so these generals make sure that they keep their bread buttered for retirement, but it doesn't even stop there. No, MSNBC, CNN, Fox News, these places routinely hire generals, put them on payroll, who also are working for these defense contractors or some foreign policy think tank, and they don't disclose who they work with and what their previous commitments and roles were. They don't, and it's not hard to do with the internet these days. but they don't even bother. They don't even give a little bit of that kind of information out. So this process in America is called the revolving door. You're able to go in, you're able to go from the government agency into the private company and then back onto the board, right? There's a revolving door between these things. And then you can become a lobbyist that goes back and lobbies the agency that you once worked at, right? There's all kinds of opportunities here. The Japanese actually have a name for this. They call it amakudari. I hope I'm pronouncing that right. Amakudari, amakudari. And it literally means descent from heaven. It refers to the post-retirement employment of senior Japanese government officials in the private sector. They get these cushy jobs because they do that. So I just want to say up front, I know this will come as a shock to some people, but the regulatory agencies are already captured. They're already controlled. It is by the biggest corporations. So who is it not by? Well, it's by the small guys. It's by the little guys.
Definitely
it's
not
by
the
ones,
fishermen, the shrimp fishermen.
the Loper Bright Enterprises, right? It's not them. So in Loper Bright, as Spike described, the fisheries agency was basically saying, we're going to charge you this much a day, and then we got some experts that you can bring onto your boat who will sit and monitor what you're doing all day. And what they actually said was, we can get this done cheaper. We can find our own expert who will do the work. And they said, no, you don't. You're going to stay inside our system and pay our fee.
You have to pay our fee.
And so they say, well, that's not right. There's nowhere that says it anywhere in the law. They were never given that level of power. And under Chevron, that automatically got kicked. It got kicked 2 courts up. But the Supreme Court looked down, grabbed that case, and pulled it right up to themselves and said, let's talk about Chevron again, which has been around since 1984. So in that segment, I just want you to notice he said that there's going to be judicial judgments chosen over agency expertise.
Yeah,
but that's not true. There's another.
It's wrong. It's totally backwards.
Right, and we're going to get into what the court's role is in just a moment in this thing, because there's actually a very progressive take there as well. But there's also this idea that this is around the world. This is everywhere. This is how government always works.
Functioning democracies, right?
Right. Okay. Well, this isn't true either. The idea is that because the experts aren't able to make the decision, and it's going to be contradicted directly by one of his guests later, that because the experts aren't making the decision, Congress cannot be as effective. We're going to actually provide a solution to that problem before we're done today.
What you mean? You can explain how Congress could be more effective?
We've got a litany of things here. We got a litany of things, but I there's one in particular that I think crowns and breaks them all, and I'm going to lay that process out. But the decision absolutely does not diminish Congress. Let me just be very clear. The problem here all along is that Congress has not been doing its job.
Yeah, they failed their oversight. And I'd like to say that as a voter, I feel bad about that because I've elected people who've participated in that process or the lack of it.
And so have we all.
All hear that regulation is bad, but regulation is a thing that makes sure that the meat in the restaurant's fridge is kept at a particular temperature. Regulation is a thing that makes sure there isn't lead in the paint that is in your house. So when we come back, I'm going to be joined by 2 very smart lawyers to help us unpack all of this, one of whom is calling this the biggest Supreme Court power grab since 1803.
I never do find out which one of them said that or declared that, but I do know that it showed up in headlines all over the place that this was a power grab.
And the implication that all of the protections that are afforded by these federal agencies would disappear that now that SCOTUS has decided to overturn.
By the way, it's sheer hyperbole. So
it's hyperbole.
Let's get into Loper Bright's actual decision. First, he said it's the biggest power grab since 1803. Why 1803? Do you know?
I have no clue, and I didn't look it up.
So the way that we understand the Supreme Court today is not how it was set up in 1787. In 1803, there was a case called Marbury versus Madison. And they basically said this branch is the one that will decide whether the other 2 are acting in constitutional fashion. We get to decide whether a question is or is not constitutional. We take it for granted today that that's how it works. But 1803, Marbury versus Madison, the Marshall Court decided that that was the way things work. And so you could almost call it the precedent of precedents. It's it would be the Mount Rushmore of precedent cases. And it basically sets the stage for almost everything that the Supreme Court does today.
So I'm vaguely in my sketchy history class. I remember that this happened. And before then, the Supreme Court was around, but it wasn't doing much.
It didn't do much. It didn't do much. It was, and it had to have a specific case and controversy brought before it. It was basically a super appeals court.
Got it. Okay. So it just waited for for people to get mad enough that they need some federal.
But they took on this role, this active role, that they could decide what was and what was not constitutional.
And this role is effectively permitted under our Constitution, right? Because that's how all civic classes are taught today.
It appears to me that if it's not, and I think it is, if it's not, we probably want something like this. The judges, there was a critique that went on through the 70s, 80s, and 90s that there was an activist court that did all these things. Chief Justice Roberts wrote the decision for this case. He is very much of this mentality that we don't want to be too activist and we don't want to move too fast. That was the conservative argument up through the beginning of this century. There has been an evolution in conservative jurisprudence over time that goes back more, and this is where I would put myself, frankly. If you're going to have this document, you should look at what it says. And this is what Justice Gorsuch ends up writing in his concurring decision, because he agrees with the majority, but he wants to make it clear that the document says certain things, and we ought to read the document. And Justice Thomas praises Gorsuch and then goes on to talk about separation of powers, which is a doctrine that flows out of the idea that there's these three branches, right? So it's not the most originalist argument here is essentially the Gorsuch argument. But Roberts isn't arguing that here. He is saying we're going to go back to the Administrative Procedure Act of 1946. And the Administrative Procedure Act comes out of an era called the New Deal and World War II.
Right. Okay. Yeah.
It's the Roosevelt years. Roosevelt has passed away. Truman is now in office, and World War II has come to an end. And they're looking at all these agencies and all these war boards that are created, and the government goes through its only historical downsizing. They just strip things and shrink stuff down. It's the last time this will ever happen. They say we've gone very big. We've done all this stuff. We dealt with 2 emergencies. We got to get our house back in order. And they start to pull things down. And they pass the Administrative Procedure Act. And one of the things that they say in there is that we the people will always be granted access to our Article 3 court. We're going to have a very Marbury versus Madison world where when a regulatory agent oversteps the line of what is actually the congressional law or what is actually constitutional, you will have access to a court where you can appear, you can maybe call for a jury, you have all the standard rights that you normally have to appeal and plead your case, starting with the presumption of innocence. You're going to have that as a benefit to you when you go. Chevron says no. And it's not me saying this. We're going to have actually one of the people talking saying this. I watched this interview, as I said, 5 times, and we have a Harvard professor here who will describe why they thought Chevron was so beautiful. And it was explicitly that it did not give you your day in court. It was the fact that there was a deference, entirely a presumption on behalf that the bureaucrat was always right. Now, you heard him talk about tainted meat. This is an old progressive trope. It goes back to near the turn of the previous century with Upton Sinclair's The Jungle. This is a 100-plus-year-old trope. And in that story, which was complete fiction and which Sinclair later admitted he made up, there were even humans, being thrown into the meat. Like they were so busy processing the meat that they couldn't afford to drag a human out of it that fell into the vat. They just simply ground them up and they sent them out too.
Was it Soylent Green?
No, that's something else that comes later. But the premise is simply that these working conditions were so horrible that he used a meat factory to help illustrate this point. And it did cause a bit of a scare. Like people were like, wait, what's going on inside these factories, right? But it never happened.
Yeah.
It was fiction. It's a dystopian science fiction novel written from a progressive position. Remember, you're too stupid. You're base. You won't do the things you're supposed to do. You won't possibly exercise basic decency and respect for your fellow human beings. We have to have regulations to protect that. Now, there's an easy answer to this tainted meat issue, Bill, and that is that it's bad business to poison your customers.
Yeah.
And you don't even need to wait for, like, the customers won't play along. Like, when they figure out that there's tainted meat coming from there, they won't go to that place and get the meat anymore. Even if the place says, wait a minute, we've cleaned up our act, they're going to suffer long-term business repercussions. There's no benefit in serving out tainted meat. You're not protected in any way by these institutions. I'm sorry. We have something much more fundamental and natural at work, which is people's greed, if you want to call it that. They want to continue to profit. They want to stay in business. They won't do that. He brings up a second thing. It's lead paint. So the progressives have a theory of innovation. And that theory is that okay, let me tell you what my theory of innovation is. Somebody spots a problem, says, wait a minute, I think I can fix that. So they innovate. They come up with something that makes the world a better place, and they offer that product out to a market. That's my naive American view. Okay. In the enlightened progressive view of the world, there's something bad happening, and a government agent shows up and says, stop doing the bad thing. And innovation magically shows up. All of a sudden, we have a 40-hour work week. All of a sudden, we don't have tainted meat. All of a sudden, lead gets sucked out of the paint. Now, if you go into a paint store right now, I will grant that there's some regulation that's brought us to this point. But is it easier to work with a lead-based paint with a oil base that used to exist, or is it easier to work with a latex water-based paint? Which do you prefer to do? I just got through varnishing, staining and varnishing woodwork for my family room, and I used, and it was an amazing thing, I used a water-based polyurethane finish on it, and it worked great. So why would I want the harder thing? Why would I want the more chemical thing? It's because progress comes because people innovate. And I'm telling you, every company has chemists on their team, or engineers on their team, or programmers on their team, or whatever it is that they're into, because they have to constantly stay ahead of something called the competition. And that competition regulates them. You want lead paint to go away? You create an alternative in the market, and you compete, and you make the case, hey, they're still selling dangerous, hard to work with toxic paint. Oh, wait a minute. We better get our engineers to work. We're a little behind this new upstart in the field. Or maybe we need to buy that company and we need to put their product out on the market. That's how progress works, but not in the progressive view of innovation. The progressive view is somebody stops somebody from doing something, and that's where all the goodness comes from.
Oh, you could think of hundreds of examples. DDT is one that comes to mind.
Oh,
Remember that whole thing?
Yeah, there's just so many of these things. All right, let's go on to the next clip.
This really started with Reagan, saying many decades ago that the era of big government is over. It's just been an attack on government. You can argue that there are too many civil servants. You can argue that there are some regulations that shouldn't be there, that are inefficient. But we've gotten carried away with this whole thing, and we've just simply decided that the administrative state, the regulatory state, is a bad thing. Without the regulatory state, I'd have diarrhea every day because I'd be eating spoiled milk. I'd be sick from paint that had lead in it. My life would be a disaster if somebody didn't actually administer the rules, and I don't need Congress doing that.
Oh, I promised you they were going to clown themselves, and this was the biggest illustration. This particular clip is the biggest illustration that Ali Veshley was out of his depth. He didn't know anything about what he was talking about. The other two may have had some level of expertise in the field, but he clearly... it might have been the very first day he even heard of Chevron deference. The era of big government, the era being over, that was actually Bill Clinton in 1995. Chevron was decided during the Reagan administration in 1984. And we've already explained why we don't have to worry about the tainted meat or the lead paint. But here he is presenting evidence that the progressive view is you have to make somebody stop something. Otherwise, well, even Ali is admitting he'll be too stupid not to eat tainted meat. In fact, he'll probably be sucking on lead paint.
So let me put this in context, right? As you're saying, Congress basically tells the administrative agencies, think about who they are, the Securities and Exchange Commission, the Environmental Protection Agency, the Food and Drug Administration, right? It says to them, do these jobs for us, right? Protect investors from fraud, make sure that there's clean air and clean water, make sure that the drug and food supply is safe, right? And then it says to the agencies, you figure out on a day-to-day basis how to accomplish those goals, how to implement these statutes, and how to enforce them against violators. This decision, which overturns, as you say, the Chevron principle, is really about shifting the benefit of the doubt. It used to be for 40 years now that the benefit of the doubt goes to the agency. Whenever Congress wasn't perfectly clear and there's some ambiguity or gap in the law, the agency gets the first kick at the can to decide, well, what would Congress have wanted here and what's the best way to interpret it? What the Supreme Court has done is throw away decades of precedent and say, oh, no benefit of the doubt to the expert agency. Rather, we, the court, will decide in every instance what every word in the statute means.
So,
yeah.
Let's pretend for a moment, let's just shift gears and see if this principle carries out in other aspects of government, if they would agree to it. Let's say that you've been accused of a crime. You've harmed somebody physically, and maybe you've even attempted to murder them. And now you're in the dock. Should the prosecutor get the first kick at the can? Should they have the benefit of the doubt that their story's correct? Or is it the case that the person in the dock is presumed innocent until proven guilty and they have a right to their day in court? What kind of system do we want? This Harvard law professor said, we want a system where the people who are acting as prosecutors, and in a moment I'm going to show you is even more, have all of the power. We don't want people to get a chance for their day in court. And we don't want them to even have the presumption of innocence. We want the benefit of the so-called doubt to rest entirely in the hands of bureaucrats.
Experts. Jim.
Okay. So this is, there's a second problem with this. And this is another case where maybe I can help them steelman their argument a bit more. The idea of a judicial branch having this ability to review the law and determine if it is fairly applied or constitutional. This idea itself is a progressive idea. These are also unelected experts, and their expertise happens to be in an important subject, which is law. And at no point are you going to see an admission by any of the three parties that participate in this interview. If you choose to watch it, we'll provide the link in the clip. We're using it under fair use, and we will share the link back so you have access to it. And you can see whether we took anything that they had to say out of context. At no point are they suggesting that these court members have this ability, this unique ability to measure the law. Now, I would be willing to wager dinner tonight. In fact, I'd be willing to wager dinner for a week that all three of the parties sitting on this panel believe that they had the ability, when they decided Roe v. Wade, to tell states and their legislators and their lawmakers that they could not make a law on abortion, that abortion had to remain accessible nationwide. There's a hypocrisy here. And again, if they were interested in being straight with people instead of making these clowned arguments, they would say, they would tell the truth. And let me just be blunt here. What she just said, and this is a Harvard law professor, is an outright lie, because the judges have a role to rule on the law. And all they're saying now is these constitutional protections that individual citizens and entities are afforded will now be reopened and people will get their day in court. But their judgments, their decisions will have to do with questions of law, not technical questions, questions of law. The technical questions matter hasn't been changed. And just because over the next 10 years worth of challenges, you may be able to find a case or two where I prove to be wrong, you will only be presenting to me the exceptions that prove the rule, that the court is once again going to begin doing its job that it should have been doing all along. And that this isn't some ancient thing that was handed down from tablets. Moses didn't bring this down. This was 1984 Reagan era stuff.
How did it get by Reagan in 84?
Well, it went to the U.S. Supreme Court and that court did it. And that court was not. So this is another issue. The progressive left does not like the court very much right now because too many of them are conservative. And you've seen the personal attacks on Justice Alito for flying a flag. And that's all that happened here. You may not like his flag. You may don't like his associations. His wife's opinions. I don't care. That these are not really germane to whether or not he should or shouldn't be on the Supreme Court compared to 100 other factors. They're bothered by the composition of the court as it exists right now. They were not bothered about the composition of the court as it existed for most of the 20th century into the 21st.
5-4 progressive, right?
Or 6-3 in some cases. And I believe Roe 7-2.
I do.
Even though the majority of justices at the time, I believe, were appointed by Republican presidents. So now there's actually some good news that falls out of this, and I want to just pull up two things. So Loper Bright Enterprises overrules the Chevron deference, which Justice Alito, the late Justice Alito, said was the biggest thing in administrative law that had happened in 75 years. So this was a huge landmark decision, and I'm very proud that we filed an amicus brief in this case. This is one of now 3 that we believe cases. There's several cases that could be considered kind of landmarky, but 3 that were major. And this is now, we were involved in Citizens United. We were involved in the Jones case, Anton Jones, restoring the property rationale to the Fourth Amendment. And now this one. We filed amicus briefs in all those cases, and we actually played, I think, a bigger role even in those previous 2 cases. But I feel like I got 3 notches of large landmarks on my belt. But there were 2 other cases that came down. One of them was called Corner Post. I won't get into all the details of the case, but I will tell you what the outcome is because it's really important. Under the Administrative Procedure Act, the 1946 law we referred to, you had 6 years to come in and file. That was the kind of statute of limitations for being able to come in and claim that you had been harmed by the regulation. The regulation itself had injured you.
Yeah. And
we had a bizarre understanding of this, particularly during the Chevron era, that if you came to exist as a company, as Corner Post did, after the law was already 6 years, or the regulation was already 6 years old, you had lost all right to appeal. If you wanted to appeal, you should have done it during the first 6 years, before you even knew you were going to exist. The clock starts running from the time that you have to begin abiding by the regulation now. That's what Corner Post did. It's a 6-year clock. Bill, let me tell you what I'm excited most about here. This means that everything is fair game now. A new enterprise comes into business, they can go after a regulation. And so if we no longer have Chevron deference, and Corner Post now says it's the first 6 years that you're under that regulation, we can demonstrate harms in these cases, and we can begin pulling some of the very worst stuff, the stuff you read from Spike at the beginning of this broadcast. We can start pulling out. We can start putting the statute of limitations to good effect. The second case was Securities and Exchange Commission versus Jarkesy. And this had to do with whether or not you had access to a court. So it kind of underlines this Chevron thing. So in this particular case, he was cited and fined, and he's like, you can't fine me. I didn't have a chance to go to court. So here's what so many bureaucracies have been doing, and what's now under threat going forward. There will be other cases to settle this. This will not settle it all by itself, in my opinion. But they have said, we write the code that you live under. So we're your legislator. We then enforce the code that you live under. So that makes them the executive. Part of enforcement is sending out the police force that will actually do the arresting, and then the prosecutor that will do the prosecuting. We are also your prosecutor. So they're going to do that whole thing. And then we get to be your court. We get to be your judge. You don't have an access to Article 3 courts. And in fact, there are several agencies in our government, the IRS is one of them, where you have to go get a hearing with them first, and then you have to do your first appeal inside their agency. So it's their people ruling on your case, because once again, they're the experts, before you're even allowed your right to an Article 3 court where you can bring in a jury of your peers. You know, because your peers are ignorant morons. They drag their knuckles everywhere, and they really couldn't possibly know what's right and what's wrong. They need experts in place.
Yeah, it's too complicated, right?
So all three of these decisions, to me, set a very positive ball rolling where we can begin to undo some of the administrative state, particularly its most egregious aspects, some of which you mentioned at the top of the show. Let's see if we can squeeze in another clip.
Twitter lawyer type people are like, ooh, it just gives Congress more power. No. Do you want to have a conversation with me about what Marjorie Taylor Greene thinks and knows about how many particulates of lead are allowed to be in the water before it hurts a child's developmental process? Do you think that she can even understand the words that just came out of my mouth, much less write a piece of legislation that solves that issue? Like, as much as I like voting for Congress, let's not pretend like Congress is always on top of the ball of all of these situations. That's why we give the experts, the scientists, the regulators, the opportunity to fill out the gaps in congressional legislation.
So
can I take this one, Jim?
Go ahead.
I'll do it in the form of a question. Who the hell that is involved in teaching law would suggest that it is up to the courts to write regulatory gibberish into the laws that Congress has passed? That's not the court's problem.
And the court won't be doing that.
So that's a complete, never will.
That's a complete fiction. It's still going to be the regulators regulating the very things that the courts are going to adjudicate. And Marjorie Taylor Greene, let me just underline it. There's you're too stupid right there. Right there. You're too stupid.
I was trying to get away from that. I was going to give them the benefit of the...
Everybody that voted for any of these Congress people that don't understand what they're talking about. And by the way, it's legendary. It's legendary what they don't know, right? They don't understand, the internet's a giant set of tubes, we had a senator say, right? They don't know much. You don't have to be an August Solon to get elected. That's not the job.
You quoted Nancy Pelosi.
Right. But let me tell you a couple of things. You've already brought up one of them, which is that the laws that are the regulations that are going to be reviewed will have already been written by these experts. So the court won't be writing these things. They'll be reading other experts, and there'll be people debating before them that they'll be looking at. That's number one.
Yeah.
Number two, the Congress also has experts come and testify before them all the time. They have committees, and they bring in experts, and the experts testify them. And many of these experts come from think tanks who go on various programs and shows and educate all of us about how things work. These are people who spend their time eating saltine crackers and drinking warm lemon water as they read the entire regulatory code or some science manual or whatever it is that they do to figure out like how this stuff really works. And they produce studies, and those studies are produced in journals, and then hopefully some element of that stuff gets out to the media. But the think tanks are there as well. Okay. So representatives are quite busy raising money and giving speeches. And no one's saying that they're doing a great job or a bang up job here too. But there's no way in which it's being suggested here, nor has it ever been the case that they were sitting down with a quill pen and composing laws as if they were some August Solons. It was never a thing. It's not a thing. It never was a thing. It won't be a thing going forward. Okay? So that is just simply a gilded version of you're too stupid. But Bill, I wonder, and I consider this something of a grace point. Does it ever occur to anybody that the government is just doing too much? And if they weren't doing as many of the things they were doing, it would be a lot easier for Congress to keep an eye on what they're supposed to be doing. They are doing a lot more than what the federal Constitution calls for based on the 9th and 10th Amendments, which, by the way, they ignore the 9th completely and rarely apply the 10th. So I have an idea. Let me say this. First off, I am holding in my hand an email from an organization called the Foundation for American Innovation. I have zero idea how I ended up on their email list. This happens to me when you're in a position like mine. You suddenly start getting stuff you didn't solicit. They have a list. I'm not going to read all the items to you in the interest of time, but they actually were anticipating Chevron, and they were saying Congress should get better at its job. Now, their list includes things like they've written a white paper called Empowering Regulatory Oversight, How Congress Can Hold the Administrative State Accountable. And I'm certain that there are things in there that have something to do with strengthening Congress's ability to get a handle on what the regulatory agencies are doing. They have recommended that the GAO, the Government Accountability Office, create a mission-focused team that reviews regulatory matters and provides greater legal and technical assistance to Congress. So a greater role for GAO in actually doing the work of looking at the expert stuff and making sure that it passes muster. They're planning a symposium as of right now called Reforming Chevron, Restoring Congress, Legislative Responses to Changing Deference Doctrines. And this is going to be done at the Anton Scalia School of Law later this year. So those are some of the things that are already being talked about by the normies. But we start off the top of the broadcast with the Right to Laws Act. I'm co-author of the Right to Laws Act. Perry Willis, we use the William J. Olson law firm. Our bill has been introduced before in the House, but is presently introduced in the Senate by Rand Paul, who has consistently reintroduced the bill. And it says very simply that the separation of powers thing, we could have called it the Separation of Powers Act, frankly. It says that every regulation that's binding upon you needs to be voted upon by Congress, because that's what the Constitution says. And because a regulation is just another name for law. And if you have a penalty or a fine or a prison sentence or something else like that attached to something, it should have actually gone through the people's body. You have a right to representation. That is how the Constitution is framed. And it starts with Article 1. And this is the job of a Congress. The People's Congress passed the laws. So we said that regulatory agents can write all the law they want, but they have to bring it to Congress if it's binding on you. And we provided a provision for you to actually challenge this when they didn't follow the procedure and do the right thing. And that's what the Right to Laws Act does. Now, I want to suggest that I'm listening to this conversation and I have a solution to the problem that they're talking about. I have a way to keep the experts in the room. We can bridge the gap here. We can keep the experts in the room, and then we can have a meeting of the minds where a solid, legitimate, people's democratic version of law emerges. And that is to pass the Right to Laws Act. Because it essentially, what it means is that the bureaucracy would come and say, does this match what you've requested? Congress, you told us to write code that would do this. We've written a bunch of stuff. Here is our homework. And then Congress would look at it and vote up or down on it, or maybe amend it and send it back. So in that way, the experts would be a help. Write the laws would make the experts a help. And the question is, does this match, Congress, what you requested? And then it would all pass constitutional muster. It provided they weren't going beyond the powers that Congress has. But there's no bureaucrats writing any law at that point. They're not controlling the law. It is now being decided by the people's representatives.
So that's like the best going forward prong of this two-prong argument. The other one is populated by a whole lot of attorneys that are very opportunistic right now and are forming law firms specifically to deal with Chevron deference opportunities.
We can only pray they are. It would be best use of lawyers we've had for quite some time. Let's do one more clip and call it a day.
Here's what I'd add, Allie, to
Jody,
let me
go ahead. Yeah.
I was just going to add to this. What this does is it throws the state of affairs into chaos. So the Supreme Court does this a lot, right? It upsets precedent. It sort of throws out decades and decades of established law and says, well, guess what? Things are changing. And what this case means is that now in all the lower federal courts, you got 850 federal judges in the country. They're going to now say, oh, we no longer defer to the expert agencies. In every case, we'll open up our dictionaries and we'll be looking at our textualist arguments to determine what these very technical statutory terms mean. And so it will mean you've got an invitation to litigate, to challenge what agencies do every day on a more regular basis. It'll invite lots of litigation, lots of disruption. And my point is always, that's not just bad for the American public that is protected by these laws and needs them implemented. It's bad for business because business relies on steady, stable state. It needs clear regulation, clear and steady regulation from agencies in order to do business. So I think the chaos that the court is sowing is really bad for the economy. It's bad for society. It's bad for business.
It's bad for business.
It's bad for business.
Okay. Is it a recipe for chaos that the people have access to their government? Is that the definition of chaos? Is that people have access to their own government?
Well, apparently, if you go to Harvard Law School, it is.
So she's right. It's going to invite litigation. And I've just gone on record a few moments ago saying, good.
Yeah, bring it on.
But let's get into this good for business thing. There's a lot of stuff I could have drawn from out there, but I found a thread from Austin Elred. And I do not understand what Austin's business was, but the thread really appealed to me because he actually explained real life dealing with these bureaucracies. And what we see here is an institution, an entire institution, an entire type of institution that is the antithesis of grace. He said the Supreme Court's Chevron ruling, and we'll put the link down in the show notes, may be the most impactful things to happen to startups in a long time in ways that people don't realize. And what I'm going to share with you here essentially means that there's lots of things that were never made, never put on the market, innovations that have not occurred because they couldn't figure out whether or not they were going to get approved regulatory-wise and what the penalty for that would be. There's literally a penalty for innovation. I'm just going to give you a sampling of some of the things that Austin said. Federal agencies could interpret unclear law in any way they saw fit and simultaneously hold anyone accountable for any law in the way they desired. In another tweet, he writes, I personally spent huge amounts of time working with Congress and on Capitol Hill, as did many others, begging for clarity on how ISAs should be treated. Many years later, federal agencies came after us, citing the very laws that we had been begging for clarity on. There is no process in the current system to go to the agencies and say, we need an expert opinion. Now, I shouldn't say no process. There's one or two agencies that do have this kind of thing, but it's still limited, and they're not guaranteeing they won't turn around and come after you. The federal agencies just have to say that you broke the law, and no explanation is really needed, he writes in another post. In another post, he goes on and says, we just wanted to be given any, and he puts that in italics, any guidance. We could have complied with anything and we were given nothing. Another post, it was kept intentionally vague with no answers to be given, up till and including the point where various federal agencies went for everyone in the space for things that we had begged for answers before, and it nearly bankrupted everyone. He says we see the same thing in crypto. The SEC continues to go after Coinbase and other players whose giant legal teams are doing everything they can possibly do to stay within the law. The SEC over and over again says, you're breaking the law. But then Coinbase asks for clarification, and he goes on to say he can't get it. And there's 4 pages of this printed out here, okay? I printed out the 4 pages. He explains how all of this works. So the idea that there's some chaos being introduced, it just isn't possible. Like, if you can read the law and you can go to court, and that is enough to pin some bureaucrats, adventurous, innovative bureaucrats' ears back a little bit, that's actually a better state of condition. Like, we may miss out on the golden regulation, the one that saves all of our lives. It is possible that there is some ideal regulation out there of which we're not aware. We don't know of any of these things, but there is always the real possibility that such a thing exists, and we're going to miss out on it because we don't have Chevron deference anymore. And it was just that one toiling bureaucrat who was such an expert, he had such the great idea, and we never got the benefit of his fruit. But what I'm going to tell you is happening in reality now is that we have thousands, if not tens of thousands of people who have started up and innovated and built ideas who stopped when they ran into the regulation because they realized it would kill them. We have industries right now where they've invented something so new that the old system says, well, you are regulated by me. And another agency goes, no, you're related by me. And it turns out they're not really either one of those things. And we can't have the thing. There's a way that they can get kelp and turn it into food that's trying to be regulated by both federal and state regulators, where they're fighting, they have a turf war, but the only victim in this thing is the entity that is attempting to bring you the innovation and attempting to comply, because the agencies aren't accountable to each other in any way, and they'll just keep hammering and screwing the people who are attempting to bring you stuff. I'm telling you, I ask this question all the time. I watched the Jetsons. George Jetson was just born a year or two ago. Where the hell is my flying car? We don't have the flying cars in all kinds of areas of life because of the way this operates. And so to suggest suggest that for the possibility of one enlightened, fantastic piece of regulation that won't happen, we should call that chaos while we have all of this innovation destroyed by the regulatory state is, to me, and because Ali Veshley doesn't know enough not to eat tainted meat. That's just not enough reason for me.
No, doesn't fly. Show prep for this, I read an article from across the pond in The Guardian that suggested that overturning Chevron deference will also stop, yes, he said it, bribes.
Oh, it might interfere with the revolving door, with the Japanese concept of amakudari. Yes, it may interfere with that. I hope it does. To me, right? If you slow incentives matter. This is an economics question. And if the regulator realizes they're about to go pass a regulation that's going to run them afoul of the courts, they didn't have to worry about this before. Maybe they stop. Maybe they pause. Maybe they don't act. Maybe they don't take a ditch and turn it into a pond so that they can regulate it for a wetland. Maybe they don't take a piece of plastic, which happens to be the bump stock. That's what Spike was referring to, and turn that into a machine gun. That was done by Donald Trump's administration. He drove and made that happen. This has been done by both parties on both sides repeatedly for the benefit of either grandstanding for political points or doing something special for some crony influence. The regulatory state has been a giant hammer to get rid of competition. I want to see its ears pinned back. We clearly have far too much regulation. The Federal Register has expanded by a much more rapid number than the amount of laws that Congress has passed. And that situation has been true for longer than even Chevron has existed. That goes back into the 1970s.
Got to throw some grace on this. I'm glad that we're having this conversation, and the Supreme Court has done us a huge favor in allowing all of us to understand and debate and, oppose one another and have the discussions that we need to have in order to sort this out in a way that benefits America. Okay,
I'm going to give you some rapid fire. I'm going to say first, I was honest with you as a libertarian where I came from on this question of democracy. That's grace. I'm being honest about what my intentions and goals and values and beliefs are. And that's what we need to see more of in these conversations. It is also the fact that we have empathetic institutions. We have courts. We have the presumption of innocence. We have a jury of your peers. We have the ability to actually get access to the court. Those things are, they're grace mechanisms. They're empathetically driven mechanisms. We imagine ourselves in the dock and say, there, but for the grace of God go I. And we treat people with innocence and we look hard at the case and we put it on the state to have the burden. So I'm going to argue that this decision and the other ones I've cited to you here are graceful.